Friends, I welcome you at Swayam platform. We are discussing a course Hindu personal law including marriage and succession. Today I want to discuss with you a topic preferential rights which is mentioned in section 22 of Hindu Succession Act. But before starting today's lecture, I want to summarize what we discussed in the last class. We discussed about the general provision related with succession, which is provided under Hindu Succession Act in section 18, 19, 20, 21. Friends, where we understand that if any person is going to distribute the property after the death of intestate may be male or female, bound to consider the rule mentioned in section 18, 19, 20. These are very essential rules, friends. And what are those rules? Full blood prevail over the half blood if relationship are same in every other respect, and the property will be inherited by the person as a per capita, not as a per stirpes. But if Act permits, then parties may inherit the property per stirpes, and the exceptions given in section 10 rule 3, section 16 rule 2 and section 10 rule 4. These are the rules, friends. And section 19 also let down the rule property will be inherited by them as a per capita, inherited by them as a tenant in common, not a joint tenant. Although they are inheriting the property jointly, but their shares are definite, clear and clear. Friends, we also discussed the child in womb, where the child in womb at the time of death of the intestate, the interest and the right of child in womb also protected. A share must be allotted to the child. And law create a fiction that law considered that the child available at the time of death of intestate, although child born alive after few months of the death of a person dying intestate. We also discussed the laws in a case of simultaneous death. In a case of simultaneous death, younger will survive the elder. This is the simple rule. And friends, now in the light, I want to discuss the preferential right of class 1 heirs which mentioned in section 22. The first observation about this is, friends, this is not related with the law of succession. This is a unique provisions which try to protect the interest of joint Hindu family and joint persons, and therefore this provision is not directly related with the Hindu Succession Act, but this provision is very useful for the purpose of protecting the common business and common property of a joint Hindu family. Friends, before starting anything, I want to discuss with you about the learning objectives of this lecture. The learning objective of this lecture includes right of preemption, essential requirement of preemption, consideration and its determination by the court, recourse in a case of plurality of the heirs, meaning of the court under section 22 of the Hindu Succession Act. Friends, preferential right, generally known as preemption, means right of priority. Suppose if a heir want to sell the property, he will give priority to the first class co-heirs. This is preemption, and this is all about section 22. Friends, just I want to explain what is the gist of section 22. The heading of section 22 is preferential rights to acquire property in certain cases. Section 22 gives statutory recognition of the rights of preemption to certain co-heirs in a case of immovable property or business of the intestate. The objective is to save an immovable property or a business of our family from being fragmented so that a family may continue to have its immovable property or its business under its control. In a simple word, Section 22 of Hindu Succession Act grants co-heirs in joint family property of preferential rights to acquire another co-heir's interest before it's transferred to the stranger. This means if a co-owner want to sell their share and other co-owners have the first option to buy it at the same time. In essence, the right of preemption aims to preserve the integrity of joint family property by allowing co-owners to maintain control over its ownership and prevent the introduction of outsider, thereby fostering harmony among the family members. So this is the fundamental observation about section 22. Right to preemption means other co-heirs have a priority right. In which circumstances? Where another co-heir want to sell the property and both are jointly inherited the property. One brother want to sell it, then another brother have a preferential right in comparison to the stranger, and therefore this rule is applied. Now I want to focus on the provision of section 22, especially clause 1, where after the commencement of this act, an interest in any immovable property of an intestate or in any business carried on by him or her, whether solely or in conjunction with others, devolves upon two or more heirs specified in clause 1 of the schedule, and any one of such heirs proposes to transfer his or her interest in the property or business, the other heirs shall have a preferential right to acquire the interest proposed to be transferred. This is the section 21 subclass 1, which provides right. This is the right conferring provision, therefore this is substantive provision of the law. By these provisions, a co-heir have a right to prevent other co-heir from selling the property to a stranger. Friends, what are the essential elements which can be deduced by the reading of section 22 subclass 1? Interest in any immovable property of an intestate or any business carried on by him or her devolves upon two or more heirs specified in clause 1. Such heirs propose to transfer his or her interest. The other heirs shall have a preferential right to acquire the interest proposed to be transferred. These are the four essential conditions of section 22. On that basis, we enable to explain what the substantial rules want to provide. Now, I am going to explain each and every ingredient of section 22 subclass 1 in order to explain the provision. Friends, what is the first requirement or first condition? First essential condition is immovable property or business. Preferential rights is given only and only in a case of immovable property and business, not in a case of movable property. Friends, what do you mean by business? The business may be separate business or a joint business. It may be a partnership or a joint family business. If two persons have an interest in a business, then other person cannot sell the rights and interest in the business without offering the first co-heirs. the property must be immovable property. Friends, in a case of Jeevan Ram versus Lakshma Devi, the Rajasthan High Court held that the Hindu Succession Act do not include the interest in the agricultural land of the intestate. The reason is that the agricultural land falls outside the scope of section 22 of the Hindu Succession Act. The subject is not within the legislative competence of union. It lies exclusively within the jurisdiction of the state. Therefore, the provision of section 22 cannot apply in a case of agricultural land. Means if a brother want to sell agricultural land with the help of section 22, other brothers cannot restrain the brother who is proposing to sell. But Rajasthan High Court ruling is now overruled by a Supreme Court decision in the year 2019. The decision name is Babu Ram versus Santokh Singh. The issue in this case was the applicability of section 22 of Hindu Succession Act in a case of agricultural land. The court clarified the law in very simple and clear manner, and what clarified by the court is the co-heirs can be entitled to claim preemption under the section 22 of Hindu Succession Act only when the property was devolved to them by way of inheritance. Otherwise, if the co-heir has acquired interest in the property rather than inheritance, then in that cases the law of preemption shall be made applicable as per the state law. Friends, the court held that the preferential right given to an heir of a Hindu under section 22 of the Act is applicable even if the property in question is an agricultural land also. The court also ruled that Hindu Succession Act 1956 should be made applicable to the succession of the agricultural land also. But friends, I want to suggest you that the interpretation of section 22 may be accepted only in the context that in a case of agricultural land, right to preemption may be exercised by co-heirs. But when we talking about the applicability of rule, the obviously land law have a different objective. Fragmentation of land is it should be avoided, and therefore law of inheritance especially given in the land law and revenue codes. But Supreme Court finally ruled out that with the help of section 22, the right to preemptions may be exercised to any one, friends. Now, the second essential condition, that is heirs belongs to the class 1. Friends, first essential condition is immovable property and business. Property means any property and also included, as per suggestion of Supreme Court, agricultural property. But second is first class heirs. Friends, these co-heirs must be among those who are specified in the class 1 of the schedule. This class consists of 16 heirs from a male intestate. When sale is to be made to the one who is not an heir in the class first, may be that their link with the joint family is so remote that the heir in the class 1 may be adversely affected in the enjoyment of the property by admission of a stranger in a property. Therefore, the use of word him or her is evident that the section applies inheritance from male as well as from the female. Friends, second essential requirement is both co-heir must be the first class co-heirs. If both are first class co-heirs, then all co-heir have a right against another persons to prevent a stranger. If they are not co-heir, then right to preemption cannot exist. Co-heirship is a prerequisite condition precedent for the purpose of application of this. Friends, now the third point is proposal to transfer. Co-heir must proposes to transfer his or her interest in the property. It implies that the provision does not apply where transfer is made by a will or by a court cell. If no proposal is made to the co-heirs in the class 1, a completed transfer is vulnerable. However, such a transfer is not void. It is voidable at the option of other. A suit can be filed to set aside such transfer. Proposal of transfer. If one heir wants to sell the property which he co-herited from a person dying intestate, then who is going to sell? First proposed to the co-heir. If there is no proposal, then transfer is vulnerable. A suit may be filed against the transfer and transfer may be declared as void. Now, after studying the section 22 subclass 1, I want to explain you section 22 subclass 2 of this rule, friends. The consideration for which an interest in the property of the deceased may be transferred under this section shall, in the absence of any agreement between the parties, be determined by the court on application being made to it in this behalf. And if any person proposing to acquire the interest is not willing to acquire it for the consideration so determined, such person shall be liable to pay all costs of or incidents of the application. So, section 22 subclass 2 talks about the considerations, how we can explain section 22 in order to understand the entire case, friends. Transfer for consideration. The question arises, what should be the nature of transfer by the heir? Friends, just I want to explain you. Now start again. Transfer for consideration. The question arises, what should be the nature of transfer by the heirs? Should it be sale, mortgage, lease, exchange or gift? Section 22 subclass 2 and 3 talk about the consideration. The rule of consideration is not applicable in a case of gift because gift is made without consideration. A situation may arise where the heir willing to transfer his interest may wish to gift on the other hand, and he may not like to make the gift to the co-heir on the other hand. How the consideration can be fixed? Friends, subsection 2 of section 22 provides that consideration may be fixed by the co-heir themselves who are the parties of transfer. If they fails to arrive at the agreement, it may be fixed by the court. Any one of the parties may apply to the courts for this purpose. Friends, now the rule is very simple and clear. Two co-heir prima facie fix the consideration for that. If they are not able to fix the consideration with any kind of agreement, then one party may approach the court for fixation of the consideration, friends. Now the fundamental question is, who will bear the cost of court? Because one heir want to sell the property, another heir now interested in purchase of the property, but they are not agreed about the consideration by agreement. Then either seller, either buyer approaching court kindly fix the consideration, and now the court is fixing the consideration for the purpose of property. The question arises that who will bear the cost of the court? In these circumstances, three different kind of circumstances may exist. The first one is the parties may agree on consideration determined by the court. The party proposing to transfer the property may refuse to transfer the interest. And the third, the party opposing to acquire the property may refuse to acquire the interest. They may refuse to transfer the interest, may refuse to acquire the interest. There may be three circumstances. After the consideration of court, both are willing to, one is willing to sell, another is willing to purchase. In second circumstances, a person willing to sell, not willing to transfer the property as rate fixed by the parties. And who is proposing that I am willing to purchase, he may refuse to purchase the property. There may be three different kind of circumstances may emerge, friends. Subsection 2 provides remedy for the third situation only. It says that the party covered by the third situation is liable to pay all the cost or incident of the application. What rule is, friends? Your brother is willing to share the, your brother is willing to sell the property, and you approach the court as I am willing to purchase the property and I have right to preemption. And on the basis of your application, court fix the amount, and after fixation of amount, you are now not interested in purchase of the property. In these circumstances, you are liable to pay all the cost and consequence of the proceeding. It is a principle of natural justice. But what will happen in other cases, friends? It does not let down any principle to guide the court in determining consideration how it should be made. Although section 22 subclass 2 talks about who will be liable for the proceeding of cost, but how the court is determining the cost, there is no legislative guidelines, and therefore in this case judicial discretion is fundamental to determine the cost of the property, friends. Now I want to focus on section 22 subclass 3. If there are two or more heirs specified in the class 1 of the schedule proposing acquire any interest under this section, the heir who offers the highest consideration for the transfer shall be preferred. In a case of competition, a brother wants to sell, two other brothers are willing to purchase the property. Therefore, in this case, there is a competition between two heirs. Who will receive the property? Who is willing to pay more than others? This is the general rule of transfer. In a case of competition, the parties. But it is very clear that there is no competition between the co-heir and a stranger. The section 22 subclass 3 talking about a competition, and competition exists between two co-heirs. This is explained as plurality of preemptor. Both have right to priority, both are claiming that we are willing to purchase. Then who will willing to pay maximum? He certainly receive the property. If there are two or more co-heirs asking for preemption, then it is to be seen who is ready to pay the highest consideration for the transfer. Only the co-heirs mentioned in class 1 can file a application in this field, and only on the scale of money preference is to be determined. Who is willing to pay maximum? Now I want to explain the meaning of court, which is provided in explanation of section 22. This section, the court means the court within the limits of whose jurisdiction the immovable property is situated, business is carried on, and includes any other courts which the state government may by notification of the official gazette is specified in this behalf. The explanation listed down: definition of court. Court means within the local limits of whose jurisdiction the immovable property situated on the business is carried on, and if is the competent court when an application for determination of consideration and preemption is the made. Means which court is important, have a jurisdiction, under whom jurisdiction the property exists or business carrying on. This is the competency of the court. Friends, in the light of entire discussion, we can conclude the right of preemption. What is the preemption? Preemption means preferential rights. Who can avail the rights? Who is the first class co-heirs? When the rights arises, when a co-heir want to sell the property, in that circumstances other co-heirs have a right to purchase the property, have a right to preference. But for this purpose, a kind of proposal must be sent to the heirs who is going to sell the property. I am willing to purchase your property, my brother. In these circumstances, now the next question is, what should be the consideration and how the consideration be determined? Friends, consideration may be determined by both the heirs. If they are not able to determine the considerations, any of them may approach the court, kindly determine the property. Which court they may approach? The court within which jurisdiction the property exists. Then they approach the court, and the court determine the rate, consideration. Then you purchase. Suppose if a brother made an application before the court, court determined the consideration, and after that brother said that no, now I am not interested in the purchase of the property. In these circumstances, the cost of proceeding will be beared by the person who is refusing now purchase the property. Friends, now the fundamental question is, suppose more than one co-heirs are there, there is a competition between them, then what will happen? Then it will happen that whose heir is willing to pay more amount will inherit the property. The simple rule, friends. Now the question is, friends, what is the purpose of section 22? The purpose of section 22 is the joint Hindu family property should be joint. There should be no stranger comes in the domain of house or the property which may affect the interest of other co-heirs. But now it is concluded by Supreme Court that the provision is applicable on the agricultural land. So this is the logical rule of the right to preemption which is mentioned in section 22 of Hindu Succession Act. But very interesting fact is, this provision is not directly related with succession, have no role either in intestate succession, either testamentary succession. But this rule have a application. This rule protect the fundamental concept of joint Hindu family interest. The use and enjoyment of the property should belongs to the family members, not belongs to the stranger. A father created the property, now two brothers are inherited the property, and one brother want to sell to the stranger. It may be harmful for the other brother. Therefore, in the case, another brother may compel first brother, kindly sell to me, and if first brother want to purchase, then first brother bound to sell the property on the basis of the consideration decided by party or by the court. In this light, friends, you can think about certain point. Whether the section 22 of Hindu Succession Act applies to agricultural land. Why this question I am putting to you, friends? Because there is a lot of discussion there are. When I discuss the scope of Hindu Succession Act, where I clearly concluded that the agricultural land is beyond the purview of Hindu Succession Act because Parliament have no legislative competence. And land revenue courts are made very clear rules. If the property is declared as a residential, commercial, industrial, then property will considered as property and everything happened. Friends, now second question is, the parties may agree on the consideration determined by the court, but party proposing to transfer the property refuse to transfer the interest. What is the remedy the other party has in such case? Suppose considerations now fixed by the court, but first brother is not willing to sell the property. Whether second brother may compel first brother? This is the open questions. You may think about that. Friends, by this discussion, I am concluding my today's lecture. Thank you, friends.